think that as mediators, you all add the most value when you, so
Green.
that's one of those things that anytime we see that, it's very harmful to the overall mediation that I think process. And one of the ways around it is saying that, and this is a hard conversation that I think a mediator has to have with.
Good morning. Today is February 19th, 2026, and welcome to the New Possibilities Hour, part of the Will Work for Food project founded by Natalie Armstrong Motan. Every Thursday morning, Jean Lawler, Michael Schwimmer, David Schraga, and I are delighted to host another cutting-edge webinar for mediators, arbitrators, lawyers, and everybody who negotiates. As you know, there's no charge for these great webinars. We ask people to contribute to a food bank if they like what they see. And since we began the series in 2020, our audiences have been so very generous in contributing to fight food insecurity on behalf of our great speakers. One of my favorite parts of the webinar each week is when we announce the running total of just how much our audiences have contributed. Jean Lawler, would you please do the honors?
Oh, always with pleasure. It's one of my favorite parts too, if not the favorite part. Well, no, the speakers, of course, are the favorite parts, and thank you for that. So this week, we have been told of a total now of $936,721.96 in contributions to food banks around the world. I would just say feed your mind while feeding the world, right? Thanks so much, everyone.
Fabulous. Thank you so much, Jean. And now for today's presentation. Today's guest is Adam Levitt of DiCello Levitt. If you're here listening to this webinar, you know who he is. He's one of the leading lawyers in the country handling complex class actions and mass torts on the plaintiff's side. His work sits at the center of cases where the challenge isn't just proving liability, but designing complex resolution systems for thousands and sometimes millions of people at once. We're going to talk about how these cases actually get resolved, what makes them different from ordinary litigation, what has changed in recent years, and the role that negotiation and mediation really plays when the stakes and the scale are enormous. Adam Levitt, please tell us a little bit about the food bank to which you would like people to contribute if they're able to do so. And then on with the presentation. The floor is yours.
Thanks very much, Jeff. I really appreciate it. And good morning, everybody. I'm Adam Levitt. And as I say, whenever I speak, as you'll see really soon, if you haven't seen already, I occasionally stutter when I speak. It's not a problem for me, shouldn't be for any of you. If anything I say isn't 100% clear, please let me know and I'll go right back over it. But anyway, the food bank that I chose for this presentation is the Greater Chicago Food Depository, which is a nonprofit that fights hunger in Cook County, Illinois. They serve more than 800,000 people each year. They have a network of pantries and soup kitchens and shelters throughout Chicago. And so it's probably the most established of the Chicago food banks. It's the one that Springsteen always speaks about when he's here in concert in town. They do really important work, and especially at this time in our country's history where there are so many people who are at risk of going hungry and food insecurity, their mission is more important than ever before. So whatever you could all contribute to them, I'd really appreciate. We contribute to them. And so that's what I got. So anyway, the hardest thing I have to do right now is share the screen. So let me handle that. Oh, hey, look at that. Okay. So what I'm going to be speaking about this morning is successful mediations and potential pitfalls in class action and mass tort cases. I spend a lot of time, as a lot of you do, resolving large-scale cases. And the mediation process can either be remarkably rewarding or really frustrating, and it depends on how you're able to frame it and approach it. And I think that in the 30 plus years I've been doing this, I've had my share of success, my share of incredible frustration. And this morning, I'd like to just have a conversation about that. So let me find out why my clicker's not working, but let's see. Hold on. There we go. Okay. So the agenda is a relatively ambitious one. There's more bullet points than we really need, but the bottom line, and we'll walk through each thing, but we'll start with why getting to the finish line is harder than ever, why cases are taking longer. Then we'll go to the central problem as I see it, with the lack of a shared negotiation universe. Then we go to the thing that I've been hitting on a lot these days in the mediations I'm involved in, as engaging in as much pre-mediation screening as the mediator and my opponent are willing to do. The next thing is the authority paradox, people actually showing up with the requisite authority, various issues that are both positive and negative in class action mediations, issues that I deal with all the time on public entity cases. We have a very active public entity practice, so we're involved in mediations on that a lot of times, and we'll talk about one of the real frustrations there. I can send the materials to the organization afterwards, and we'll circulate it out. And next we get into resistance to early discovery and what that means for the possibility of early resolution. We'll go from there to a quick discussion of mass torts and the proof of use fiction. And then we have two systemic distortions that mediators need to recognize, then getting through to the real decision makers, and then we'll open it up to Q&A. So moving just real fast about our firm, we founded our firm about 8.5, almost 9 years ago now. We started with 11 lawyers in Chicago and Cleveland. We now have 100 lawyers in Chicago, Cleveland, New York, Washington, Birmingham, Alabama, Las Vegas, San Diego, and Santa Fe. And we're opening in London this month as well. One of our partners is out there now. And we are a complex trial and issues firm. We do high stakes, large scale cases. We aim to be in leadership of all the cases we get involved in. You might have seen recently there was a jury verdict in Judge Hellerstein's courtroom against BNP Paribas for its funding of genocide in Sudan. We represent a class of 23,000 Sudanese refugees. That was the initial bellwether case, and our firm was lead trial counsel in that case. We're currently focus grouping in Riverside, California for another class action trial that we're taken to trial in May against Honda. And we try cases around the country. We focus group around the country. And so we're one of the firms. A lot of firms call themselves litigation firms. We are a trial firm, and the results show it, the appointments show it, and it was one of the things when we created the firm was really important to us. So starting out where we are on the first point, why getting to the finish line is harder than ever. And many mediations don't fail at the table. They fail before the process even starts. And a lot of mediations today, as a lot of you know, the court orders them sometimes. The parties aren't really connecting on it. The parties come without any sort of shared expectations. They send people without any meaningful authority, without any realistic path to resolution. and without a true appreciation of the risks on both sides and quantifying those risks. And I think that a lot of times these days, certainly, mediation is being treated as a box you need to check off, or a signaling device, or the delay tactic, or just trying to learn as much as you can about what the other side's thinking. And on the mass tort side, certainly, or on the single event injury side, a way to intimidate or scare or emotionally cripple a plaintiff. The bottom line is that this is not a critique of mediators in any way. It's a critique of how the system is using the mediation process. And I think that until and unless we get to a place in each mediation with shared expectations, you wind up with a frustrating day. So the main problem, or the first problem, is a lack of a shared negotiation universe. I think that, as the Venn diagram shows, not the most complicated Venn diagram, but one nonetheless, is that it requires overlapping universes, not just coming in saying, we're settling the case today, or we're not settling it today. The mediation fails when one side has no intention of approaching a range that the other side could view, sorry about that, as good faith. And the parties aren't merely far apart, they're actually in different conceptual universes. And this isn't some sort of posturing or anchoring, it's simply structural misalignment. And it's the sort of thing where you come in and within an hour or two, you're shaking your head saying, what are we doing here? And you start working on other stuff. And this sort of lack of a shared negotiation universe dooms the process from the outset, because when no overlap or common ground exists, no amount of mediator skill can actually create that common ground if the parties just are seeing things, one's white, one's black, one's up, one's down, just doesn't matter. And the parties very often leave far more entrenched than when they showed up. The clients could conclude that mediation simply is a waste of time, when in reality, the process wasn't used in the right way. So in terms of lessons about what's worked, and trying to reach an overlapping universe, I'll use our GM case, our GM 5.3 liter case that we litigated for 9 years before Judge Chen. Getting a jury verdict in October 22 was a class action case relating to a piston ring defect in GM's 5.3 liter engines. We took it to trial. It was a 3-week trial. The jury was out about 4.5 hours, gave us everything we asked for, and we ultimately settled. But in advance of our final mediation, where we got the case resolved in January of last year, we had an interim period where we had the mediator meet with each side in advance after each side gave a 3-page greatest hits sort of document to find out whether they were in the same world. And the benefit of that is we learned pretty quickly that we were not in the same world. The mediator said, look, I make enough money. I don't need to waste a day with y'all. I'll see you again down the road. We're just not going to have this now because it won't accomplish anything. And it saved a huge amount of time, and it preserved the parties' credibility. And I think it was one of the things that ultimately led to the mediation that finally worked. So in talking about what the pre-mediation screening looks like, and I just jumped ahead on this, and it's not gatekeeping, it's professional triage. The mediator gets a short written statement from each side, not advocacy, just focused on expectations, risks, relevant settlements, or verdicts in other cases, and goals. Then you have a 45-minute, 60-minute call with each side where you talk about where you are, and ultimately the mediator serves that vitally important role of making the call of, are we anywhere close to each other that would make our day worthwhile? So that's something I feel strongly about. Obviously, not all mediation styles give rise to that sort of pre-meeting. However, a lot of them do. So to the extent that I'm able to do this in my cases, I think it's something that I would always do if I could, because I don't like wasting time. Likewise, I think that in the pre-meetings, I think what the mediator has to do is really find out, are they mediating the same case? Are we talking about individual or class-wide resolution or not? Is there any realistic overlap in good faith expectations? And is the mediation process being used as a genuine resolution effort or for some other reason? And I think that this saves everyone a huge amount of time because it prevents mediations that are destined to fail. I think also anytime, whether it's in a mediation statement, whether it's in a greatest hits pre-mediation document, whether it's in a focus group, forcing yourself or forcing your team to sit down and really frame what they think is important and what's not is always an important exercise. And I think just the act of the exercise is an important thing. But the other thing also is from the mediator's perspective, this sort of advanced screening process, it protects the mediator's credibility as well, because rather than create a situation where the mediator is dealing with a couple of frustrated parties and thinks ultimately that the mediator isn't doing a good enough job at getting it done, this sort of an approach only lets a mediation with at least a moderate sense or a moderate chance of success to actually happen. So, and also it preserves mediation as a serious tool rather than simply as a box checking ritual. I'm sorry, go ahead. Was someone asking something?
Oh, go ahead. Go ahead, Adam.
I'm sorry. Okay. Shifting to another important thing that I think is key in every mediation is the issue of authority. Who is showing up with authority for their client, or what authority is in the room? And for us, that needs to be a non-negotiable in any mediation, because without authority, a mediation session is just a meeting that just has many risks. So the authority issues, I think, need to be raised and addressed before the mediation even happens. Someone has to show up for each side with authority up to a reasonable number. Frankly, in a perfect world, the authority should reach the plaintiff's opening demand. That's not going to happen all the time, obviously, but it has to be in a realistic universe. And this has the added benefit of requiring a decision maker at a corporate defendant, for example, to better understand the case and their potential exposure. And I think also one of the things that I've experienced, I was actually involved in a case a number of years ago where we mediated with a mediator in Philadelphia who unfortunately is no longer with us, with a German car company. And it got to the point that something extraordinary happened in the room, and I'm sure that a lot of you have seen it as well. The client was there, the in-house counsel was there with ultimate authority. He sent his outside counsel out of the room, sat him down in the hallway, and he got the case resolved between himself and the mediator. It was one of those things where, because he understood his company's risks, he wasn't listening to his outside counsel's constant yelling and bluster about where the case was going to go. And he understood from a business perspective what it was going to actually take to make this case go away. And that was important. So that was an example of having someone show up with authority and an understanding of what's going on. The other reason why having someone from the company there all the time with authority is important is that one of the things that we all experience is when the outside counsel and in-house counsel are on this constant infinite loop of patting each other on the back saying, you're right, no, you're right. And it happens again and again and again. And it's one of those things where in that sort of situation, a mediator can very easily sense when that sort of mutual backslapping is happening. And hopefully, and I think that's a very harmful thing in any case. Frankly, in going back to our General Motors case, it cost General Motors, without exaggeration, about $100 million more than it would have otherwise, just because they kept on shaking their fist at the sky saying, we're right, why is no one seeing it? But a talented mediator could actually sit them down and say, this is what's happening here. This is where your real risk is. You might not want to hear it, but this is what's going to happen. And I think that sort of thing, and having someone there from the company with an understanding of the case, is vitally important. So shifting from there to class action mediations, the main structural issue that kills a class mediation is one side won't consider a class-wide settlement. If I show up in a class action case making real clear that we're only interested in a class-wide settlement, and the other side, after spending their 45 minutes or whatever with the mediator comes back and says, well, they'll take out the individuals. I'd be better off sitting at home. I have no need to engage in that kind of conversation. And it's one of the most common and frustrating issues in class mediations. And in class actions also, plaintiffs' counsel cannot ethically trade class claims for individual relief. So that's not even a negotiation gap. That's actually a category error. And I think that this sort of issue, and now putting it on the mediator again, I think it's important to identify in any sort of pre-mediation screening if the defendant isn't open to a class-wide settlement and a meaningful class-wide settlement, because if not, it really doesn't accomplish anything. Now, I will say this, and I'm sure that you all who are mediators understand this as well, and this goes back to what I was saying about our firm and why I think it's important that we've structured our firm the way that we have. And that is, if a firm is able to try a case, and the other side knows that a firm is able to try a case, I think that the ability to do that is the ultimate safety valve in any mediation. Because I'm sure you've all been involved in mediations where there's someone on the plaintiff side who gets really, really angry at a counteroffer, smashes his fist on the table and says, I'm leaving. And the answer is, where are you going? You have nowhere to go, because we know he couldn't actually take the case to trial. By contrast, we have no problem with that. We don't hear something we like. We don't hear something that we think is a reasonable and fair settlement. We will try the case. And anyone up against us will understand what that means, and they will understand those risks. And I think that sort of thing as well is very helpful for a mediator to truly understand, because if a mediator is able to say, look, if you don't resolve it here, there is a next step, there is a final step. This will go to trial, and your risk at trial is X. And that's not just a theoretical risk, it's a risk that is born of experience, is born of trial ability and skill, and it lets a mediator use that as a meaningful hammer as well. Uh, Hang on one second. Another issue that is a problem, and this has happened with a number of defendants I've mediated with over the years, they've tried linking the attorney's fees to being a material term of any settlement. First of all, I think that creates an unfixable conflict because obviously every dollar that goes to the attorney's side of the line is a dollar less than the class is going to get. But number two, I think it crosses that line of forcing a conversation about attorney's fees in advance of or at the same time has class-wide relief. And as we all know, that's a serious problem. So that's one of those things that anytime we see that, it's very harmful to the overall mediation process. And you all, as mediators, for those of you in the room who are mediators, I think that's something, if you've experienced this, I think that's one of the harder issues. And I always have a hard time working through it. And the easiest thing to do is say, we're not doing it. We need to actually separate that. But a lot of times, if that's just the last step between getting a meaningful settlement or not, the mediators sometimes lean on plaintiffs' counsel in a way saying, let's just make this happen. And I'm not sure that's the right way to go, in all honesty.
Adam,
Yeah.
what is the right way to go?
Get the class-wide relief in first, then have a conversation about what the attorney's fees are and not link one to the other. In other words, if we don't agree on attorney's fees, there is no settlement is not the way to do things, because at that point, it forces a lawyer, first of all, to cross the line between his own interests and the class's interests. And it also creates a situation where it's clear that what the defendant is saying is that every dollar that goes to the lawyer's side of the line is $1 less on the class side of the line. So it's a very thorny problem.
So, Adam, even if it's not explicitly mentioned, and you insist that the attorney's fees will be negotiated later, isn't it kind of a known secret that the attorney's fees are going to be within a certain range, a certain percentage of the class recovery? And don't certain judges have certain reputations for making awards within certain tight ranges? And don't certain law firms have reputations for getting their attorney's fees within a certain range of the class recovery?
Well, yes and no. I think that for me, my preference is if we can't reach an agreement on fees after class-wide relief is entered into, I would rather have a contested fee fight literally 10 out of 10 times. I am absolutely happy stepping up in front of a court, representing what we've done, defending what we've done, and explaining why what we've done entitles us to whatever fee we're seeking there. But I think that in common fund cases, it's easier. I think that there we're simply asking for a percentage of the fund. It gets thornier in cases where it's not a pure common fund that you can seek, that, where you can seek a percentage of the fund as fees. So I think that it depends on the case as well.
And do you find that defendants will be willing to enter into a settlement for the class and leave open the issue of attorney's fees for a contested hearing in court?
I have a contested fee fight coming up in Los Angeles on May 18th, so stay tuned.
Okay.
Yeah, so we do have that. It doesn't happen as often as I'd like, uh, just like we don't get to trial as often as I'd like. But it's just one of those things. If 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 you've worked a case in the right way and you've entered into a meaningful settlement, you should have no problem stepping up and defending what you've done. It's the lawyers who reach an early settlement, well, while a motion to dismiss is pending, for example, not even truly understanding sometimes the value of their case. And they're settling for a fraction of trial value that could potentially create a serious problem. Now, I can get into the whole conversation of claims made settlements and why I think that courts are ignoring the Supreme Court in the Boeing case from years ago. And I think that these days is creating all sorts of structural issues, both in mediation and in fee briefing, and rulings on fees. But that's a longer conversation than we have the time for now. But certainly happy to have that conversation with anyone who'd like to have it. So shifting gears away from the class action area to the public entity area, representing state attorneys general and sub-sovereigns as well. A lot of times what'll happen is, and this is pretty specialized, I'm not sure how many of you have worked in public entity settlements or mediations. One of the real problems is in most large AG actions, there is a multi-state group of state AGs who are negotiating as a group, not working the actual case all that hard and waiting to get some sort of the settlement, which is frankly, it's usually lower than those states that actually retain outside counsel and go it alone. And I can show again and again and again examples of states we've represented where we've gotten a material multiple over what the multi-state got. But one of the issues is this, and I actually experienced this in a mediation about 6 weeks ago. The defendant said, we can't settle with your state because if we do, the multi-state is going to want the same thing. And our answer is, that's really it's a structural issue. It's not a valuation dispute. The issue is, first of all, I could always say that falls into that great category of not my problem, but it actually, as a result of it happening, it becomes my problem. Because if I can't settle a case as a result of a defendant saying, well, if I pay you, I'm going to have to overpay everybody else. And I think there's ways around it. I think one of the ways around it is saying that, and this is a hard conversation that I think a mediator has to have with a defendant in that case and say, look, what this state is doing by taking the case all the way through is differentiated from all the other states in the multi-state. That's number one. The other thing that I found that works really well is if a defendant needs 6 months, 8 months, a year to reach a global settlement with all the states in the multi-state, what I've actually worked on in the past, and I'll share it with all of you, is we reach a settlement, but we keep a single term in the settlement agreement open. It could be something as inane as the color of the ink we're going to ultimately sign in, or whatever it is, or something a little more material than that. And we agreed to keep it open for X months with a finite end date, unless there's a further conversation. And that sort of thing gives a defendant the flexibility to go out and do what it needs to do, while at the same time giving us, representing our client, the safety and security of reaching an actual settlement. Obviously, not getting it resolved on the spot, but knowing that it's done. So I think that's an important thing in that respect. Shifting gears to the issue of discovery early on in advance of mediation. If you're going to have early mediation, I think it's important to at least have an early and meaningful information exchange between the parties going into the mediation. And the problem that we've seen recently is that a number of the defendants in our cases, they resist even very targeted early discovery. And I think the problem with that is if we don't have that discovery as plaintiffs, we lack the information to evaluate the risks. The defendant says the demand that the plaintiffs making isn't based on any facts, and then it becomes another wasted day. So I think also in a pre-mediation phase, a mediator should really figure out whether there's a way to force an early information exchange. And I think that if the defendant is unwilling to engage in an early information exchange, I think it says an awful lot about how interested or not interested a defendant is in reaching a meaningful settlement at that early mediation. The other thing that happens on the mass tort side an awful lot these days is the defendants insist on proof of use, documentary proof of use, for example, or whatever heightened standard they could advance. And I think the problem with that in mass tort cases, and we deal with it also, obviously, in claims made settlements in class action cases, an affidavit is, in fact, real evidence. I know that we've heard a lot of defendants argue, and they say it in this way, that we can't let something come in on a class member's say so. The fact is, an affidavit is more than that. It's a sworn legal document. Affidavits are used every day for all sorts of things, but for whatever reason, in mass tort and class action resolutions, they get challenged in a way that they shouldn't get challenged. But for example, real world consequences of that are in cases like the hair relaxer case, which is a pending MDL in Chicago that my partner, Food DeBras, is lead counsel of, or the paraquat litigation, where we're also heavily involved. One of the things that we're seeing in each of those implicates an actual product, actual usage. With paraquat, it's an over-the-top crop herbicide that kills everything green. And what's been happening is they first went to a licensing system in 1978. If you got hurt, if you were using it before 1978, you developed Parkinson's and you passed away, for example, and you don't have your license. What the defendants are trying to do in that context is say, no license, you don't have any claim, but there wasn't a license at that point. So this whole idea of requiring some sort of unrealistic documentary proof when an affidavit or some other information can actually help you close that loop and make it work is a serious problem. And I think that in mediation, to figure out exactly what would be required in mass tort to satisfy a grid requirement, for example, is very important. So I think that's just another example of where there can be a misalignment or a disconnect in all of this. And then a couple of systemic distortions that I think are important to recognize as well, that a settlement is not a legitimate settlement simply because it's out there. I think that a lot of times, especially in long-running MDLs, a settlement shows up and a judge becomes very invested in forcing the settlement through, even if it's not the right settlement. And I think that we all know a number of settlements where it's happened, where they've collapsed under their own weight. A defendant's been required to add a lot more money to the settlement. And I think that treating a settlement or an allocation grid as a fait accompli is a mistake, especially in the mass tort context, of course, where you have individual lawyers with thousands of plaintiffs who are able to actually torpedo a settlement by keeping their clients out of that settlement. So say, for example, in a mass tort, the settlement has a 95% participation threshold. If 3 or 4 or 5 plaintiff lawyers with a substantial number of clients say this settlement isn't working for us, and we're not going to put the majority of our clients into it, we're not going to recommend it to our clients, the result could be cratering all the work that's happened, and that would be unfortunate. Likewise, as we've seen in the Johnson & Johnson efforts in talc, 3M's unsuccessful effort in earplugs and elsewhere, trying to use the bankruptcy process as a litigation weapon and tying things up. But that's more off point than what we're really speaking about here this morning. But it's just one of those things where these are tools, unfortunately, that can land a proposed settlement or a mediation on a siding as being a failed mediation if these sorts of structural issues aren't prospectively dealt with. And then this goes back to what we were talking about earlier, getting the real decision makers in the room, because you cannot settle with someone who never hears the actual risk. The gatekeeping problem, as we know, and we were talking about the infinite loop, information is filtered through insurers, committees, multiple layers, counsel, defense firms with interests that aren't necessarily the same as what the client's interest is. And a lot of times, critical risk information never reaches corporate boards or actual decision makers. So I think as mediators, the important question is who needs to hear this and make sure that a direct risk communication gets through to the people at the company in order to really let people understand what this is all about and why a potential resolution is worthwhile or maybe not worthwhile. But I think if the decision maker isn't receiving full information, you're not going to get clean feedback, and it creates, again, structural risk in any mediation. So the key takeaways from all of this are how getting to the finish line requires honesty about whether the race can actually be run. I think that as mediators, you all add the most value when you screen in advance of any mediation. You require people with real authority showing up at these mediations, understanding the facts, risks, law, and external factors that inform the overall case, and identifying structural misalignments as early as possible. And sometimes the right answer for any mediator is not now, not yet, not like this. And I think that's something, saying no is a very powerful thing. And saying you guys aren't ready yet, I think is something that can help the parties ultimately go back and figure out when they're actually ready. So I appreciate your time. Thank you very much. I'm available for any questions if you'd like. I think we have a little more time. So
Yes, Adam, thank you. This
sure.
was fantastic, and there are plenty of questions. Let me start off. What are some of the signals that let you know, yeah, this really is a good time to mediate? This really is the time when we know enough, they know enough, we can get a deal done now.
I think the answer is when each side is feeling some real risk. I think that each side has to understand what's at play. And I think that once each side understands that, and whether that's a trial setting, whether it's a positive ruling in a case, a negative ruling in a case, whether whether one side's witnesses are getting really beaten up at deposition, whatever it is, I think that in those types of situations, a skilled mediator could actually make each side think about those risks. And I think that understanding risk is really what helps create a successful mediation.
Now, following up on that, we mediators often think that mediation is the tool or the device for helping people to understand risks that they don't yet understand. So earlier you showed those Venn diagrams with the small overlapping wedge in the middle of perhaps a settlement range. Can you use mediation to create an overlap where the overlap might not previously have existed at all because of exchanges of information, greater understanding of risk, and so on?
I think the answer is yes. And I think that one of the really important things is if you're a mediator who is known as someone who really works up the pre-mediation effort, who really learns what the case is about and comes in with real examples and battle-tested examples of why what one side's thinking isn't right and here's why. And I'll give you a really good example that I experienced. I had a mediator say to me, you're going to win a trial. You're going to win in the circuit. You're going to lose in the Supreme Court. I think they're actually going to accept this case for A, B, and C reasons. And I think that you can decide what you want to do. But I think that you have to understand the way that I see it. And I've mediated thousands of cases, this mediator said, you're going to have this problem at the end of the road. And I might not agree with him because I actually, what I did at that point, I risk adjusted for what I thought the cert possibilities were. And I over exaggerated it, just thinking that let's say there's a 30% chance. Let's risk adjust it down by another 30%. But it made me think of something in a way that I hadn't actually thought of it. Whether or not I ultimately agree with it isn't really important. It's the fact that I got something that stopped me and it made me think. And I think that sort of thing, to answer your question, a skilled mediator can actually make that happen.
Now, Adam, also the Purdue Pharma litigation has had tremendous implications on mass tort cases, who's involved, who ends up being parties to the settlement, and how those settlements come about. How have mediations and settlement efforts changed in the wake of the Supreme Court's activity in the Purdue litigation?
I'm not sure I understand your question exactly. If you want to clarify it a little bit, I'd
Well,
appreciate it.
in terms of bringing in parties uh, to the settlement, whereas courts perhaps previously had greater power to bring in additional parties to a settlement, and now it has to be done voluntarily.
I think obviously that has a major effect because if it all has to be a voluntary process, you could always say, I don't want to play. So I think it has an effect.
And okay, let's open it up. I have a couple more questions, but let's make sure we get others' questions as well. Gwen Owen, you've had your hand up for quite a while. Please pose your question.
Okay, thank you very much, Jeff. Adam, thank you for your presentation.
Sure.
I found it a very illuminating and very interesting, particularly your introduction that you are basically trial lawyers and so on. I want to pick you up on one of your slides where you said you had a safety valve, and the safety valve was that you could also trial the case.
Yes.
Now, I'm kind of wondering, is this a threat? Is it a case of I talk quietly, but I carry a big stick? Which is that conducive in your Venn diagram demonstration to producing a mutually acceptable solution, or are you trying to impose your points of view prior to entering into a final negotiation?
That's an excellent question, and thank you for asking it. I think that when an opponent is aware of what you're able to do, and it's not just saying you can do it. Obviously, every opponent, we research our opponents, they research us, they know exactly what we can do, we know what they can do. There's no secrets ultimately anymore. I think that knowing that that's a key variable and a possibility, I think that it informs what happens in terms of getting a case resolved. And it may actually expand the shaded area of that Venn diagram.
Yeah, I kind of wonder. You didn't mention any particular. I don't want to take up too much question time. This will be my last question. You didn't mention the timing of creating this safety valve. I can see sometimes if you're struggling to actually come to a conclusion within a time limit, then possibly you could say, well, we're trying, but this is where we're going next. Or if you say it early on, I'm kind of wondering about the talk quietly, carry a big stick approach.
Right. I think it's a few things. I think that early on, the knowledge that the other side has of your actual ability to take a case to trial informs a number of things that they do. In one mediation that I recently did, I was able to actually say that you have a binary choice right now. Every motion's been ruled on, everything is finished. It's settled the case or go to trial. There is no middle ground at this point. And at that point, when that's all you have left, and that is literally, in one case we have now, all we have left is a September 3rd trial date, they can settle, they can try it. We're perfectly happy to try it. But I think that's something they need to really think about in light of where we are.
Okay, thank you very much. Thank you.
Sure.
Adam, let's talk a little bit more about the mindset that mediators bring to the work. We as mediators, we like settling cases. All else equal, we would rather see a case get mediated and settled than not.
Sure.
And yet you seem to be counseling mediators to be a little more detached from some of these outcome goals. How would you describe the mindset that mediators should bring to the work?
Not detached, I don't think. I think that the opposite. I think that what I'm actually counseling is speak to the parties early on, understand where they are, because while I know you all like resolving cases, we do also. But I think that if you're going to get people into a mediation session where there's no chance of anything positive happening, as good as you think you are, you can't create something unless you're able to show actual risk or change what the parties are thinking. But if someone's showing up thinking that a case is going to settle for X, and the other side thinks it's going to settle for a minuscule fraction of X, unless you can get the parties into the same universe, I think it just creates incredible frustration and instability between the parties. Because if each side walks out of the mediation angry at each other, I'm not sure that that's really a helpful thing going forward. So what I suggest is to be really involved, be more involved, not less involved.
So, Adam, think back to a really tough mediated settlement in which you were involved. What were some things that the mediator did which might have been invisible, that people perhaps never noticed, but without which the deal could not have happened?
Can you clarify a little bit? I just want to
Sure.
understand exactly what
Well,
you're.
what have mediators done subtly, delicately, which made a huge difference in whether or not a case actually got settled?
They've let me understand what was really important to the other side, and if it was something that I could actually agree to, they would be much more flexible on some of the things I was interested in. And I think that that type of thing really facilitated one settlement that I had about a year and a half ago.
Can you be any more specific about it?
Sure. Sure, absolutely. There was a question about, there was one main case and about 8 or 9 satellite cases. And the main case and one of the satellite cases had certified classes. The other ones uh, were not certified yet. And the issue was, if we were able to reach individual settlements in the non-certified class states and run the entire settlement, the class settlement, through the certified states, we would get a lot more flexibility. And we ended up reaching that agreement because, in our view, at the end of the day, our obligations to a certified class are very, very different than a state where there's a pre-certified class, so to speak, or a non-certified class. So I think that sort of thing really helped things work, and it was a creative thing that we heard the mediator, we heard what was important to the other side, and through our understanding of that, we were able to resolve a case that might not have otherwise gotten resolved that way.
Hmm. And Adam, let me ask the last question. There's obviously no one mediator who's right for every case and every circumstance and every person. But if you could design the golden mediator, if you could design the ideal mediator, what would be some of the attributes that the ideal mediator would have?
I think that my favorite mediators are the ones who really learn our case and who really understand what's going on. If I feel like a mediator is mailing it in and they don't really understand what's happening in the case, I think that's really frustrating for me and frankly others. I think that, so my perfect mediator is a mediator who really engages in the case, makes me learn things about the case that I might not have otherwise understood. And I appreciate, and look, we've all been around the block enough times. I know that as a mediator, you're going to go into each room and play one side off the other. And I fully understand that. The thing that I don't like are the fake shows of anger. I don't like when the mediator tries to impose his or her overall personality on what's happening, because I'm not sure that always works. I think that if the mediator views him or herself as a partner in the overall process rather than anything else, I think it's the most effective thing. Because I'll never forget about 15 years ago, I was in a mediation at Jams, and the mediator got really angry at us, said, "You can all go fuck yourselves," and walked out of the room. Uh, he he came back in, he sat down. I said, "You understand you're on the sell side in this building. You're not on the buy side. Uh, there's a lot more of you. So let's not do that." So that mediation failed, but I've mediated with him afterwards. That never happened again. But it's that sort of thing that I don't think is helpful. And so I think that if a mediator serves as a partner and a trusted partner, if they come to you and they say, "Look, this is really as far as they can go, or this is where I think you have a serious problem," I think it helps everything, because if I trust you and I think you've really worked with me and with the other side, and you sit down with me and you say, "It's not going further than this. You have a hard choice right now." At least now I know I'm making a hard choice with the advice or guidance of a trusted partner, rather than someone who I know is just trying to reach a preconceived result. And I think that's the best thing.
Words of great wisdom. Our time is up. Adam Levitt of DiCello Levitt in Chicago, thank you so much for a really wonderful presentation. I know that I'll be contributing to the Greater Chicago Food Depository in your honor. I'm confident many others will as well. Again, thank you so much, Adam. A wonderful presentation. And with that, we are complete.
Thank you very much, everybody. Have a good day.